officially a welcome for the record, because we're only recording as of now. We're now moving to our first session where we actually have some kind of country reports. Again, this comes with the caveat that the time slots are very short, and obviously the beauty and depth of these jurisdictions cannot be explored in full in just 20 minutes. And you can book us at a moderate fee for a week-long seminar, or month-long, depending on how much you pay. So a hotel in Dubai, perhaps. Anyway, they tend to sponsor all sorts of things these days, but probably not that. Anyway, we have our first comparative session. We're going to hear about Scotland, Ireland, and New Zealand, all of which have reasonably developed systems for the recognition of de facto relationships, not without criticism, and indeed, in one case, very much under reform at the moment. So very pleased to have as speakers today, Kate Dowdalls, KC. This K doesn't quite roll off the tongue yet, but we're getting there, who was appointed as the Scottish Law Commissioner in July 2018 and is leading the Aspects of Family Law project. And prior to taking up her appointment, she had many, because you don't give numbers, years of experience in practice as a solicitor and an advocate. And she took silk in 2013. But her appointment will come to an end, as I learned from your, in May. And then, my daughters love this, she will become a sheriff, the sheriff principal of South Strathclyde, Dumfries and Galloway. So, and then she will take up that role in June. And I did explain to my children what it actually is. Then we have Kathryn O'Sullivan, who is a senior lecturer at the School of Law at the University of Limerick in Ireland, and she specializes in family and property law. And she has published widely in highly respected national and international journals, and of course has written a fabulous chapter for this project. I think it was actually the first one submitted. But things haven't moved so much, so you didn't have to revise it every single week, so that was good. And then we have online with us Margaret Briggs, and we've seen she's there already, and she has taught at Otago University also for many years, no numbers given. And her teaching and research has focused mainly on criminal and property law, and in the latter particularly on relationship property law. And she has contributed to many, many comparative studies, including the one on registered partnerships and also marital agreements. And of course, she was our #1 person to ask when we needed a New Zealand chapter, and she delivered a marvelous one as well. So we are delighted to have these three speakers for this panel. And with that, I will hand over to Kate.
Thank you, Jens, for that very full and kind introduction, and for refraining from making jokes about large star badges and where will I tie up my horse in my new role. My family are thoroughly enjoying those jokes at the moment. I'm finding it somewhat tiresome. Thank you for inviting me to come and speak today about the work that we're doing in Scotland on reform of our existing provisions on cohabitation. I think, I can't remember whether it was Andy or Jens said earlier that the discussion in England and Wales about cohabitation have been ongoing since the early 2000s, I think. We've been talking about cohabitation in Scotland for decades. Our cohabitation law that is in place at the moment came about because of a Scottish Law Commission report, which was published as long ago as 1992. And it took 14 years after that for any meaningful progress to be made. And we now have the Scottish legislation is the Family Law Scotland Act 2006. Now I've got, all right, this is a bad start. This isn't working. No. I'm going to speak to you only for 20 minutes or so, so I'll try and do a really quick canter through the salient bits of information. Yeah, that's great, thank you. That I think that you need, and I'll be happy to talk. Actually, I'll talk for Scotland later on if you want me to about this legislation and our reforms. First of all, what I'll do is I'll take you through what we have just now. I'll tell you a bit about the reasons why reform was thought necessary, and then I'll explain to you what our recommendations for reform are. The legislation has been in force since May of 2006, and it is a limited scheme for the making of claims by former cohabitants on separation and death. I want to be very clear that the provision for cohabitants is not the same as that for spouses and civil partners. Very, very quickly, we have just 5 sections in the 2006 Act, which is a much bigger piece of legislation dealing with a number of other issues. But the sections on the slide, you'll see deal with the meaning of cohabitant, sections 26 and 27, rights in certain household goods, money and property. 28, which is the really problematic section, I'll talk to you about that in a minute, that's financial provision. And section 29 deals with applications to the court by a survivor for provision on intestacy. The big rules, if you like, in relation to claims on separation are that they have to be made within a year of cessation of cohabitation with no exceptions, so no discretion to allow late claims. The only matters for the court to consider when it's determining a claim for financial provision in separation is whether there has been net economic advantage derived by a cohabitant from the other cohabitant's contributions, or whether a cohabitant has suffered net economic disadvantage in the interests of the other cohabitant or any children. The only orders that are available are orders for payment of a capital sum or what is described in the legislation as an amount in respect of the future economic burden of childcare, and the court can make interim orders also. One thing to observe is that the provision for payment of an amount in respect of the future economic burden of childcare is dependent on a consideration of the past net economic advantage and disadvantage that's been enjoyed or suffered during the relationship. That it is, there's no specific or additional rule or test for the making of that order. Claims on death are dealt with under section 29, and they must be made against the deceased partner's estate within 6 months of death. And that's obviously a very, very tight time limit, which has come in for some very substantial and significant criticism. The Scottish Government some time ago made a commitment to increase that time period to a year. That hasn't yet happened, but that is a commitment that the government has made. The court can make an order for payment out of the deceased net intestate estate for payment of a sum of money, and also an order for transfer of property is available in a death claim. In reaching a decision about an order under section 29, the court can take account of the size and nature of the deceased net intestate estate, any benefit the survivor has or will receive in consequence of the death from somewhere other than the net intestate estate, the nature and extent of other rights and claims such as a spouse or children or anybody else, and any other matter that the court considers appropriate. But the court cannot award more than a surviving spouse or civil partner would have received. In our project, the Scottish Law Commission didn't tackle section 29 and intestate or death claims for cohabitants, because at that time, and still the Scottish Government's working on review more widely of the law of succession in Scotland. So we didn't touch that at all, and I don't claim to be an authority on that, on the law and the authorities and in relation to that piece of legislation. The need for reform was identified virtually as soon as the 2006 Act came into force in May of 2006. Awareness, everybody talks about awareness, and we have the same problem in Scotland. We've had this legislation since 2006, and yet we are told that there is a significant lack of awareness among the general population about their rights, such as they are on cessation of cohabitation. And solicitors that we spoke to during the consultation process told us that the range of understanding goes all the way from people thinking they have no rights at all, right up to we have the same rights as spouses and civil partners. Particularly, we have the same rights as spouses and civil partners after a period of time, which people kind of make up. They say, well, after 5 years, it's just the same, isn't it? It's not. So that is a significant problem and remains a significant problem. And it's something that reform of legislation can't really do anything about. We need to have the government on board to inform and teach and help people to understand what the law is. One of the difficulties also was the definition of cohabitant. It was regarded as being outdated and not reflective of modern relationships. The definition depends on an analogy with marriage and civil partnership, whether for same-sex or opposite-sex couples. And although we're told it works reasonably well in practice, the phrase, you know it when you see it, is one that we've heard many times during our project. It is nonetheless something that's been criticised as being somewhat old-fashioned and in need of work. I won't trouble you with sections 26 and 27 of the Act. The issues with those sections really relate to concepts and language in relation to the idea that people work on the basis of housekeeping allowance and like, so I won't deal with that. The criticisms mainly focused on section 28 of the Act, which you'll remember I said is a section that deals with orders for financial provision. That's the section that deals, that includes the time limit, what the orders are, what the tests for the orders are, etc. So the criticisms of section 28 were that the policy objective was unclear. What's it all about and what's it intended to do? The remedies were inadequate, and in particular the absence of a property transfer order being available to cohabitants was criticised. Time limits too short and it's inflexible. There are no guiding principles. In other words, the court and practitioners aren't given any guidance so that they can make decisions or settle cases on a principled basis. The test is too complex. The notion of economic advantage and economic disadvantage is straightforward enough, but the difficulty is that once you've identified net economic advantage and net economic disadvantage, what do you do with it? And so that's a problem. There's no reference to resources, in other words, affordability in the legislation. That's regarded as a problem too. And there was no provision at all in the legislation for agreements. Just as background, most of you in the room are English lawyers. In Scotland, the contract is king, and whether that's in the divorce situation or in cohabitation, even where there is a statutory regime, if parties contract to do something that departs from the statutory regime, that contract will be enforced and will be enforceable. In the divorce, Family Law Scotland Act 1985, which deals with financial provision and divorce, there's some limited provision that allows the court to interfere where an agreement's not fair or reasonable at the time it was entered into. And that sort of provision was sought by our consultees. I was seen as a lack in the 2006 Act. Now, we have been to the Supreme Court, so we have a leading case, Go Against That, which was a decision in an economic disadvantage case. I can talk about it later if you like, but I don't want to go into the details of it just now. And I declare an interest because I represented as junior counsel the unsuccessful Mr. Grant in the Supreme Court. But what the Supreme Court did was that it, in effect, told us that the underlying principle in the legislation was fairness to both parties, which is fine because the legislation doesn't say anything about fairness. It doesn't use the language of fairness at all, which is contrary to what was recommended by the Scottish Law Commission in 1992. But unfortunately, that as a principle hasn't been sufficient in itself to prove particularly helpful. So our work today, very quickly, and I've given you this slide, I understand the slides will be distributed at some point, so that if you want to, you can see the discussion paper, which was published in February 2020, our report, which was published as recently as early November last year, and there's an executive summary for those who don't want to plough through the entirety of the report. We've been working on reform of the legislation since I took up my post in, I can't get this to work again, sorry. since I took up my post in 2018. That's it. Yeah. That's great. Thank you. I don't know what it is that I keep doing that's causing it. It's undoubtedly me that's causing the problem. We made 14 recommendations. I won't tell you about all of them because all of them, well, it would take too long and all of them won't be of particular interest to you. Two things that we didn't recommend, and I've noted this because of a couple of things that were said in the earlier presentation, I think by Andy. One is we're not recommending a registration system, and that for precisely the reasons why where there is a registration system in other jurisdictions, it tends to be underused. We concluded that a registration system wouldn't benefit the people who need the legislation the most, that is the most vulnerable, because for a variety of reasons they wouldn't register their cohabitation. There wasn't support in any event from our consultees for a registration system for that and for other reasons. We're also not recommending a qualifying period of cohabitation for cohabitants. There was no support for that among our Scottish consultees. So we're not doing that. Where there was limited support for it, when you dug a bit deeper, there was such a range of suggested periods that it rendered any period that we would have selected entirely arbitrary. Also, we don't recommend that the same regime applies for cohabitants as applies for spouses and civil partners. And that again was simply because there wasn't support for that. So a difference is maintained. Our bill, we published the report with a draft bill, and our bill contains a new, a recommended new definition of cohabitant, removing the analogy with spouses, that in line with what consultees wanted us to do. One of the problems with the analogy with marriage and the loss of that analogy is that you lose the bells and whistles that go along with the marriage analogy, such as a minimum age and excluding people in forbidden relationships. So we were keen to put that back in, to have those safeguards in place and to give some certainty. And also we were very keen that we ensured that a cohabiting relationship could not involve a set of circumstances that might be criminal in nature or involved an incestuous relationship. I won't take you through the details of it, but it is all on the slide. So far as financial claims are concerned, our test we made very simple. The orders can be justified on the application of guiding principles and reasonable having regard to resources. So we've, if you like, recommended curing the issue about not having anything in the legislation about affordability, but also we have introduced a set of recommended that a set of guiding principles be introduced. It has taken forever for us to frame those guiding principles. And one of the problems that we had was that while people said what we've got doesn't work and we need more guidance, when we said to them, what do you want us to do then? Hardly anybody came up with any ideas. So we were digging around trying to extract ideas from practitioners and academics, and we had an advisory group of people saying, no, come on, tell us what you want us to do. Very, very difficult to get people to explain. And that's because it's a difficult concept. What is it that you actually want to achieve here? So where we got to was that the economic advantage and disadvantage principle in itself wasn't a problem. The problem was the gap after you'd identified economic advantage and disadvantage. So we have retained that, and the first principle is the economic advantage derived by one cohabitant from contribution made by the other should be fairly distributed. So we're saying there's fairness and there's got to be distribution of those advantages. And similarly, economic disadvantage suffered by one in the interests of the other or a relevant child should be fairly compensated for. And frankly, that was the best that we could come up with. It seems to fit the bill, it seemed to work. And only time will tell whether the Scottish Government likes it enough to take it forward, and thereafter whether practitioners and the courts like it enough to work with it and make it work. One of the things that our consultees also wanted us to do was make some sort of provision to safeguard against serious financial hardship arising as a consequence of the ending of the cohabitation. Now, even on divorce in Scotland, we don't have long-term future maintenance post-divorce. We don't have that regime. We have a very limited provision for periodical allowance, which is post-divorce maintenance after the end of a marriage. In a cohabitation, we haven't created any mutual obligation of alimentary support or provision. So we're not trying to give something that isn't there during the relationship to people at the end of it. This is really a kind of compensatory award, a real hardship, acknowledging that sometimes there may be real hardship and there's a need to meet the needs of a person over a very short period of time, where there's a likelihood of serious financial hardship. If I had to guess at it, I would reckon that there might be some pushback against that, but it was something that our consultees wanted, and that's the reason why we've recommended it. And universally, of course, the economic responsibility of sharing the burden of childcare, or burden, didn't like the word burden either in the legislation, so we changed that to responsibility. Was that principle has always been popular, and universally that was sought to be retained. So what consultees really wanted, we found, was clearer guidance. And to help with that, we had the guiding principles in place, and we thought, well, what do we do with that? How do we help? What else can we do? And we came up with factors relevant to the application of the 3 guiding principles. These are in some ways borrowed from our 1985 Act, the legislation that deals with financial provision on divorce. Our aim would be to have the guiding principles and the factors read together in the same way as the principles and the relevant factors are read in the 1985 Act. Won't take you through these. I think there are 3 or 4 slides, and you can have a look at those later if you are minded to do that. We also came up with some factors that were relevant to the application of all of the principles. One of those is the terms of any agreement between the cohabitants, so that it is clear if there's an agreement, that agreement has to be taken into account. We've also recommended provision that says that unless the agreement's varied or set aside by reason of another introduced new provision that we've recommended, then the terms that the court won't make an order that is contrary to the terms of that agreement. Now, that does no more than reflect the law as it is in Scotland. An innovation was to put in a factor which is related to the economic effect of behaviour, including abusive behaviour in relation to the couple. Now, in our existing provision, behaviour isn't mentioned at all, and in the provision in relation to spouses, behaviour is mentioned to the extent of saying behaviour won't be taken into account at all in relation to financial provision. So this is really new. We're not suggesting that there should be damages, if you like, if there has been abusive behaviour, but what we're acknowledging as our thinking has developed in relation to domestic abuse and coercive control and all that goes along with that and all the consequences of that, is that sometimes there will be economic consequences arising out of particular forms of abusive behaviour, and that economic consequence is something that ought to be taken into account when the court's making orders for financial provision. All the other circumstances of the case, so it's a free-for-all after that, obviously, too. We have recommended some additional orders be put in place, obviously retaining capital sum, payments for no more than 6 months for the relief of financial hardship, transfer of property, which is really what people wanted, and incidental and ancillary orders in relation to protections, interim protections, such as use of a family home while there's a pending application for transfer of property, that sort of thing. We haven't recommended introducing pension sharing. It was favoured by some consultees, not by others. The most persuasive comments were that that could work in a proper property sharing regime, but other than that, it wouldn't really work. There were difficulties raised in relation to, well, we've got legislative competence to think about. That wouldn't have stopped us, but it would have been a complication. But other complications related to the need for pensions legislation to be amended, pension providers to amend their pension schemes, and evidence that we saw about the difficulties in implementing pension sharing provisions for cohabitants because of competing claims, the difficulty in identifying when a cohabitation starts and ends, and various other complications. So all told, we decided not to recommend pension sharing. Time limit, we have recommended retention of the 1-year time limit, but the introduction of judicial discretion to allow late claims on special cause shown. Cause shown wasn't enough because mere ignorance of the time limit would have been sufficient to go over the line. And exceptional cause shown we thought was too high a test because that would have to be something really extraordinary. Special cause shown is something that relates to the individual or the couple or the relationship in particular, and that seemed the better fit for us. With a backstop of 2 years, we took the view that where a right to claim was created by statute must be clear about when that comes to an end. So we have a backstop of 2 years after which no claim can be made, whether on the exercise of discretion or not. And again, I think Andy mentioned our private negotiation agreeing to extend the time limit. We have recommended that. That was something that we didn't think up. Solicitors that we spoke to during a consultation process said to us, it would be really useful if there was a bit of flexibility and couples were able, without raising an action, and without the pressure of having to raise court proceedings, to negotiate their case to a settlement, because very often they're very close to settling and then they have to raise an action, and that just sets all sorts of hairs running. So we have recommended that that be included with some fairly strict limitations on how it's done. It has to be in writing. It has to record the date the cohabitation ends, because that's a critical date, plainly. They have to confirm they're agreeing to negotiate towards settlement, and that is the reason for the extended time limit. And obviously no proceedings will have been raised at the time that the agreement's entered into. I've already mentioned financial agreements. I take it I'm running out of time, Jens. Yep, I've already mentioned financial agreements, so I won't talk about that. Can I just say the response to date to our recommendations has been very positive among the Scottish family law community. I don't expect everybody to like everything we've recommended. I'm sure there'll be some that say we could have gone further, and some that say that we have gone too far, but we recognise that we can't please everyone. Solicitors and counsel and the members of the judiciary that we've spoken to have told us that the recommendations, if implemented, will improve on the existing law, and it'll advise them to enable them to advise clients and make decisions more easily, and that more cases should settle, which will help with throughput in the courts. So if that is the outcome, and if it's done, then that will be a success. We are, however, completely dependent on what Scottish Government now does. We're told that the Scottish Government will consult on our bill. We're reasonably confident that there might be a Scottish Government bill in 2025. Seems a long time away. You'll all be aware, of course, the Scottish Government at the moment has various bigger fish to fry than this, so I doubt that it will be top of the priority list. The good news, however, is that Jens and Andy's publication is unlikely to be held up in any way by anything significant happening with our proposed reforms, and that will take the heat off Professor Norrie to come up with a revised chapter for the for the book. If anybody wants any more information, please do not hesitate to contact me or the other members of my team. The contact details are on the slide, and I think I just might have slipped in under the wire there in my 20 minutes. Excellent. Thank you all for your attention.
Chris is very dominant.
There we go. Good morning, everyone. And I suppose I'd like to start by first of all thanking Professor Scherpe and Andy as well for inviting me to participate in their collection and inviting me to be here today to talk to you. So what I'm going to do is, before I start into the nuts and bolts of the Irish legislation, I'm just going to give you a little bit of historical context for it, because I think that kind of sets it up better for you. So cohabitation wasn't a thing in Ireland, and a lot of that was to do with the influence of the church. So it would have been totally unacceptable for a long time, and it wasn't until the 70s and the 80s that things started to slightly change in Ireland in terms of moving away from church teachings dictating how family life should be, and that picked up momentum, we'll say, in the early 90s. So in the 1996 census, they recorded for the first time the rate of cohabitation, and there was 30,000 families, cohabiting families. And that then really gathered momentum, I suppose, through the late 90s and early noughties. And by 2006, there was 105,000. And I think the latest census figures that we have are for 2016, and it's about 150,000 families now. But because of the influence of the church, there would have been a constitutional privilege given to the marital family, and that still exists today. So it's on a pedestal within the Irish Constitution, Bunnock na hÉireann. And one of the ways of kind of addressing the growth in cohabitation was to look at changing the constitution. And so there was a review done in 1996 about that. They recommended changing the constitution to be more inclusive. That didn't happen. So by the early noughties, it was looked at again, and the Law Reform Commission published a report, and that report formed the backbone of the legislation that came in 2010. So it's got a dreadful title. It's the Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010. I'm just going to call it the 2010 Act. But it introduced a presumptive scheme that applies unchanged largely today, and it's based on a safety net or redress model. So the easiest way of explaining it, or I think for today's purposes, is just to explain who do you have to be or what do you have to do in order to get relief. So the first step is that you have to be a cohabitant. And that's defined as one of two adults who live together as a couple in an intimate and committed relationship and aren't related to each other within the prohibited degrees of relationship and aren't married to each other or civil partners of each other. And in helping the court to determine whether somebody fits into that category or not, there's a list of factors. They look at the duration of the relationship, the basis on which the couple are or were, we'll say, living together. Do they have children? Is there a child of one of the parties that's a part of this family and the other is a social parent or whatever? financial arrangements between the couple, and then how they present themselves to the world. So do they carry themselves as a couple, I suppose. And as was mentioned earlier this morning by Andy, I think it's implied in the legislation that the relationship had to be sexual at one time, but the fact that it isn't now doesn't mean anything. It's not relevant to dictating whether the couple are or were cohabitants, but they did have to be at one point. So then you move from ticking that box and you come to qualified. You have to be a qualified cohabitant. That is the introduction of qualifying time periods. So the couple have to be living together as a couple for 2 years, as was mentioned earlier, if they have a child, or 5 years otherwise. And there is no flexibility in the legislation on that. Also, as was mentioned, there's no aggregation of time periods allowed. So the on again, off again scenario doesn't fly with the legislation. It has to be the period of time. So say it's 5 years, and that has to end, with the breakdown of the relationship. So immediately prior to the breakdown of the relationship, you have to be together, or the clock stops if you're not. But because they're quite strict on the qualifying periods, there has been a bit more flexibility around the living together. So the courts have said that you don't have to be living in the same house the whole time. So if the reason that you're not living together is because of work or ill health or things like that, that's fine. It just can't be related to the relationship and the breakdown of it, or it's going through a bad patch. And the other thing is that there is a partial exclusion for married cohabitants. And the rationale for that is that if one of the cohabitants is married to somebody else, they're not considered a cohabitant until they're separated from their spouse for the period of time that's required to get a divorce, so that the spouse will always get first dibs in the case of a relationship breaking down with the cohabitant. It will be open to the spouse to take their action for a divorce or a judicial separation or whatever, so that they don't get done out of it because provision is made for a cohabitant. And then once you're a qualified cohabitant, you also have to show that you are financially dependent on the other party because of the relationship or because of the breakdown of the relationship. That's not required if it's a claim on debt, but if the relationship breaks down, you have to show this financial dependency. And I'll be talking about that again in a while, because that has been hugely influential in how it has or hasn't developed the whole scheme. So once all those steps are met, then the discretion is with the court to make an order if it's just and equitable to do so. And in deciding whether to make an order or not, they can look at a list of factors that are set out, and they largely mirror the factors that apply on divorce in Ireland. So they look at the finances, the resources of the couple. Is there a spouse in the equation? Does one of the parties have, or both have spouses? What's the situation with regard to responsibility toward children, whether of the relationship or otherwise? The duration of the relationship, the degree of commitment, the contributions they've made, the effect of those responsibilities undertaken during the marriage on earning capacity, disability and conduct. Two things that are on the list as factors on divorce and aren't on the list for cohabitants are they don't look at accommodation needs for cohabitants, and they don't look at the standard of living for cohabitants. But everything else is more or less the same as on divorce. And then if the court decides that they do want to make an order, there's a preferred hierarchy of orders. So first stop would be a compensatory maintenance order, as it's called. Nothing to do with compensation. That's just what they call it. And there's no time limit as to the duration that those orders or that maintenance will be payable for, because we don't do clean break. So it's just go on. And if maintenance orders aren't appropriate, then they can go for pension adjustment orders, which we have, and are increasingly important in an Irish context, and divorce anyway. And if pension or maintenance orders aren't appropriate, then as a last resort, you can go for property. Just as an aside, the rationale for that was that there was huge fear around the division of farms and property in Ireland at the time divorce legislation came in, and that played a big part in the rejection of divorce referenda in Ireland in the 80s. because we had a ban on divorce. I'm going off on a tangent here, but there was a ban on divorce in Ireland. There was a referendum in the 80s to bring in divorce. The division of property was really controversial at that time. It is still an issue. And so when this legislation was being drawn up, the Irish Farmers Association had strong opinions on how it should be dealt with. And so for lots of reasons, property is a very touchy subject for us, and property adjustments are very, very touchy subject. And for that reason, it's like a last resort for the type of order, at least in theory, for cohabitants. And then the courts have broad scope to vary, revive, or suspend any orders. So as I say, it's very kind of free and easy in terms of how the courts can interfere with orders made in Ireland. It's a 2-year time limit for taking applications, and we do have cohabitation agreements provided for in the Act. There are stringent formalities, and that's been criticised by some for the threshold that has to be met for a cohabitation agreement to be accepted. And even if it is ticking all the boxes, there is residual judicial oversight to interfere with it anyway, in the case of serious injustice. I'm only doing one slide on succession and death, but that is to say that our legislation dealing with intestacy and antestacy didn't make any provision for cohabitants or anything. So this is where it came, and it was under this act that it was allowed for or provided for first. And the courts look at those factors that I already mentioned. Did I mention them? I did. So those factors, what provision is made, let's say what provision is made for an applicant, and they also look at other beneficiaries and the implications for those if an order was made in favour of a cohabitant. And I suppose an important part of understanding the Irish scheme in this regard is that we have fixed entitlements for spouses, whether on intestacy or on testacy. We have forced heirship. So, and we don't go with the statutory legacy angle, we go with a fractional share approach. So it is clear in any given estate exactly what a spouse would get, and that caps what a cohabitant can get. So the cohabitant can't do better than if they were a spouse. And we have no discretion in our Succession Act either for a spouse to apply for more provision. So it is fixed, you take it or leave it, that's it. So they can transfer that over and say, that's the cap. And as I mentioned earlier, you don't have to show financial dependency for a claim on death. And this is where my presentation takes a kind of it's quite structured to here, and now I need to just kind of order my thoughts, because as I was preparing for this, as I was saying to Andy earlier, this is where it goes a little pear-shaped for me. And I just hope that I can be concise in explaining how it works in practice, because I thought I knew the answer. And this week, because I knew there would be a stronger practitioner element for this talk, I wanted to nail down what happens in practice, and then I got conflicting stories. So if we look at start at the start, I suppose, in terms of how much litigation has been taken under the scheme. If you do a search for the term qualified cohabitant in the court service website, or on Westlaw, they tally, which is good. You only find 8 reported cases, and this legislation came into effect. It was commenced in early 2011, so that's 12 years ago, and there are 8 reported cases. The majority of those are dealing with applications on death, and the others that aren't are dealing with kind of peripheral issues. So, for instance, there was one last year that was looking at whether the couple, whether the woman in the relationship was even in Ireland for long enough to have jurisdiction, for Ireland to have jurisdiction for the case. So these kind of issues aside, but nothing really digging into the provisions of the Act, will say, in terms of making provision. That's the first thing, 8 reported cases. And one solicitor, just in Spain, is on the record in 2015. He wrote an article about it, and he said that it was an expensive risk to take. So from a practitioner's perspective, and I spoke, as I say, to a number, it is a risk to take on a client to pursue a claim under this legislation, because, as was said to me, in order to win in a trial, they have to be effectively destitute. And if you don't win, you don't get paid. So they were saying, you know, the more likely it is that a person might win, the less they have, and then they might be found not to be a cohabitant or something. So there was definite practitioner reluctance in some parts to actually taking an action at all. And kind of building on that, I looked at the legal aid angle. And so we have civil legal aid, and civil legal aid report for 2021 said that they assisted 275 cohabitant disputes. Now there were 8,500 and something between divorce and judicial separation. So 8,500 versus 275. But still, I was surprised at the 275 as a number, considering I had been told these don't happen. And there's no record of what happened in those 275 cases. Were they cohabitants? Were they considered to be cohabitants? Were they not? What did they get? No idea. Because those cases will go through the circuit court, and there's no record of effectively what happens in terms of outcomes in the circuit court. So there's a big hole in the understanding of what's going on there for the legal aid angle. But as was pointed out to me, they are the cases that are likely to run. So because they have the financial, I suppose, aspect covered. Our case is being settled. So I was across the board told that that's the best scenario. And actually and when I say I spoke to people, I spoke to family law specialists. That was who I went for. The main people will say dealing with these cases. And one person said they never had a case go to trial because everything they've ever been involved with settled. And I originally had, in preparing these slides, said, oh, likely that there weren't many, and you know, the lack of precedent and stuff. I would revise that now, because I would say that actually there is probably a fair amount of settlements going on, and I have a couple of kind of points on that. So, and I suppose there's no record of these because we don't have empirical research kind of teasing this out. So this is just based on what I've learned, we'll just say, from talking. So one of the practitioners said to me that they would only kind of get involved in a cohabitant's case if the person, the financially stronger person, had a couple of million. And they may just want to make it go away, and they'll settle, and then I'll get paid. And there'll be something there for the cohabitant. And I was trying to kind of figure out, well, if, and I suppose I should make the last point before I go there, provision in the claims that are successful are going to be less than what you get for spouses, and provision on divorce in Ireland is limited anyway. It would be known, it's not particularly generous, and you're going to be getting less. So you're not going to be getting a big payout as a cohabitant if you tick all the boxes anyway. And there's all the hoops to jump through to be a cohabitant. So I was kind of trying to think, well, why would there be such kind of a willingness to settle? And a part of the reason for that is that in order for the applicant to take their case, they're going to be discussing how the relationship was committed and intimate. And that's going to involve a lot of personal details being discussed in court. And that I have a couple of examples that I got from practitioners of cases that they were involved in, and people don't want to go down that road, so they will just almost just pay off to some in some limited amount, by all accounts, to get out of the situation and to prevent it from going any further. And the second thing is that if you are the cohabitant, you who's making the application, you're the financially weaker person, you know you're not really going to have much of an entitlement if it does go to court. So probably you'll be accepting of something quite limited anyway. And one of the, and I think I possibly have time to give a couple of examples from the practitioners that I spoke with. And before I mentioned those cases, just going back to the point of, you know, the intimate details being divulged in court and whatnot, there was a case that was one of those 8 that was reported. It was a case where a person was claiming to be a cohabitant, but and the other cohabitant had died. And the other cohabitant had died, and they were married. And the spouse was saying that they were still married. It was a concurrent marriage scenario, which I didn't have when I wrote the chapter. The court found that the purported cohabitant wasn't a cohabitant. And the whole judgment was looking at those intimate details of the relationship between the deceased and the cohabitant, supposed cohabitant, and the relationship with the spouse. And it came down to, well, the wife was saying, he has 300 plus pieces of outerwear in my house, and she can't have that much because she has a smaller house and she was sharing with somebody else, so she didn't have that much storage. And it goes down to this kind of nitty gritty. The wife was also had to explain why she wasn't sleeping in the same bed as the husband. And then it turned out he was drinking, and all of this came into why was he going on holidays with the cohabitant, and person who claimed to be the cohabitant, and not on holidays with his wife. And all of these, it felt kind of intrusive even reading it. You're thinking, God. So I can understand why people don't want to go down that route, because they are the bits that are going to determine whether you're a cohabitant or you're not. But coming back to the provision that's made and the thresholds that are set by the courts, which is kind of hidden from kind of public view because we don't have judgments teasing these things out. I was given an example. There was a woman who was represented by legal aid. She was renting. She started up a relationship with this man, moved into his house. They lived together in his house for 12 years and they broke up, and she ended up back renting. And she took a cohabitation claim, and the circuit court said she wasn't financially dependent because she was just back where she started. And so that was kicked out. There was another case I was told about, and the solicitor in question said to me, I mean, this is the kind of case, the next one is the kind of case that you would think the act was made for. 18 years together, 3 kids. All the assets were in the man's name. So the home was in his name, he had the pension, he had everything. And that cohabitant only got child maintenance and a declaration of a small equitable interest in the home, which would have been based on her contributions, because we use the purchase money resulting trust, which is you get in what you get out what you put in. So it's not that she was given anything there, but she got nothing extra under the 2010 Act. And that was another circuit case decision. And so my interpretation of the situation from what I've kind of heard is that the legislation itself is restrictive in how it's set up, but then the application of it is also very restrictive by the courts, which means that it's not really developing in the way that it potentially could have. So the aim was to limit protection to particularly vulnerable people, and that was stressed a lot, and that was an honourable intention in terms of who they wanted to protect. But the eligibility is tightly defined. Litigation is costly and very risky if you don't have legal aid backing you. The outcomes are uncertain, and those that we have kind of seen, coming out where they do get something are limited. I didn't mention it, but there was a case where a 10% benchmark was kind of mentioned. So there's a lack of precedent, particularly from the superior courts, and that just fuels more uncertainty, and that just impacts on litigation and settlements going forward. And that statutory financial dependence filter is particularly problematic because it kind of stifled the legislation from the beginning, and it didn't develop organically the way you would have thought it could by cases coming through courts, considering all the different aspects of the legislation. And I wonder whether judicial discretion could have been better used to set the threshold in Ireland and allow it to develop more than just choking them from the off and not having those cases coming through. So, thank you very much.
Thank you. Now, Margaret can take control of us from New Zealand, I hope.
Yes.
There she is. And I think
I'm here. Am I audible?
very,
Very, I will see if I
Thank you.
and I think you're entitled to share the screen and can do anything you want.
So I can share the screen with you. There we go. Well, good morning, everyone. First of all, thank you to Jens and Andy for inviting me to talk to you today. I think I'm actually here to spread the word that New Zealand does things a bit differently. Now, while New Zealand hasn't achieved what I would describe as complete relationship unification between spouses and cohabitants, I think we're certainly heading down that path. And we've certainly embraced a functionalist approach to couples in cohabiting relationships, or as we prefer to refer to them, de facto relationships. And that is especially in the context of family property entitlements at the end of a relationship. Now, before I get into any of the nitty-gritty, I'll just take you through a few preliminary points here. In terms of relationships that are recognised in New Zealand, we recognise 3 different types of relationships. And you'll see there that 2 are formal marriages and civil unions. And we also have the 3rd type of relationship, which is our de facto relationship, which is your unmarried cohabitants. De facto relationships are defined in 2 different statutes, which I will refer to in a moment. Now, the point about de factos is they've got no official registered status whatsoever, but with some exceptions, the partners are treated just the same as married couples and civil partners. But for all our seeming liberalness there, we still adhere to a traditional concept of coupledom within the de facto relationship. So what we're looking for is an intimate dyadic relationship between 2 people. So, for example, we don't legally recognise polyamorous relationships, and nor do we recognise the non-intimate friend or domestic relationships that some jurisdictions have begun to recognise. Now, that said, our Supreme Court, which is our highest court, currently has a case before it relating to a polyamorous relationship between 3 people who are arguing about the division of their family property. And we are currently waiting to see what the Supreme Court tells us about that situation and whether they think our laws are on the right track or whether we need to recalibrate again to take into account these polyamorous type relationships, these new emerging types of relationships. So just moving on, I'm not going to burden you with too many statistics. Suffice to say that it's just a familiar refrain. As you can see, just like many other countries, marriage rates have been in steady decline, and people are waiting a lot longer to get married these days than they were 50 years ago. Conversely, de facto relationships in New Zealand continue to climb. In the latest census results, which came out in 2018, a census is done every 5 years in New Zealand, it was estimated that just under a quarter of all people in a coupledom relationship were in a de facto relationship, so in an unmarried cohabitant relationship. Those figures are potentially a little skewed because the census asks people to tick a box, so they self-identify as to whether they are in the de facto relationship or not, and their perception of their relationship may not align exactly with the legislative definitions of what a de facto relationship is, and I'll get to those in just a moment. Also, you can see that it's the younger age groups that account for the majority of de facto relationships, and a de facto relationship is often a precursor to marriage. So then in New Zealand, how do we recognise de facto relationships? Well, rather confusingly, there are two separate definitions of a de facto relationship, and these apply in different legal contexts. So the same couple could be in a de facto relationship for certain purposes, but not for others. So to give you an example, the couple might find that they are deemed to be in a de facto relationship for, let's say, welfare benefit purposes, which might mean that if one member of that relationship is not single, then they miss out on a benefit. But then when you cross over to another definition, which I'll come to in a moment, that's the definition of de facto relationship under the Property Relationships Act, that same couple might be in a de facto relationship for that act. So they don't necessarily sync together, which is rather confusing. So on the slide before you, you will see the definition of de facto relationship as it appears in our Legislation Act 2019. And there have been several previous iterations of this definition in earlier legislation. So the definition that you see in this Act is what I've called the default definition, and it applies unless another enactment expressly provides otherwise. And I'll get to that definition in a moment. So this Legislation Act definition often, although not exclusively, but it often applies in contexts where there is some interaction required between the state and the private citizen. So the state wants something from the private citizen, like in tax law, or the private citizen wants something from the state, like a benefit, for example. And that is often the context where this Legislation Act definition applies. And you'll see there that it is indexed against marriage. And as Kate was mentioning in relation to Scotland, in that sense, it's possibly outdated. So under the Legislation Act, to be in a de facto relationship, you must live together as a couple in a relationship in the nature of marriage. Now, different state agencies apply their own individual policies and guidelines for determining what is required. So I've just given one example there, a case called Rooker, which is still a leading case, and it related to entitlement to a welfare benefit. And in that case, the Court of Appeal said that what is required for a relationship in the nature of marriage is emotional commitment and financial interdependence. The relationship that Rooker was in was most dysfunctional, and the court held that it was not a relationship in the nature of marriage, and therefore she was not guilty of benefit fraud in that case. Now, if we put that definition to one side, I think really for today's purposes, the rather more pertinent definition is that appears in the Property Relationships Act 1976, but as amended in 2001. And it's those 2001 amendments that have made a huge difference. In 2001, we moved from the previous system, which was premised very much on marriage, and we've moved away from that since 2001, very much more to a functional approach where de facto partners have much the same rights to family property as their married counterparts. So this second definition, which I'll come to in a couple of slides, is different to the Legislation Act definition. But before I get to that, I just want to, for those of you unfamiliar with the New Zealand system of relationship property sharing, I just want to make a few points about that. It's very different to the English discretionary system. So it's a type of deferred community of relationship property scheme. And it crystallizes on separation or the death of one of the partners, whichever comes first, I guess. At which point the Act crystallizes and it kicks into operation. And what happens is all of the property, potential property, is identified, and it will either be classified as relationship property or separate property. With very few exceptions, relationship property is divided equally. Separate property is generally not shared, and it will stay with the person who has legal title to it. Now, what I have not mentioned there is New Zealand's love affair with the family trust. There are a great many family trusts in New Zealand where people have put the family home and pretty much everything that they possess into a trust. And they do that for a number of reasons. It initially started out to avoid rest home subsidies so that people wouldn't have to pay for care in their old age. But since then, it has morphed into a situation where people try to get round the equal sharing provisions of the Property Relationships Act. And so there is a great deal of property in trust. I should say that the Property Relationships Act does have some trust-busting provisions, but they are fairly weak. They're somewhat toothless. Just moving on, the Property Relationships Act is a default or opt-out regime. So people are quite free to contract out of the provisions of the Act if they don't like the look of them. There has been a relatively recent study done by the Boren Foundation where 1,300 odd people were surveyed about their views about the Property Relationships Act. And of the 60% of those people who were interviewed, 60% were in a current relationship, but only 10% had made agreements to contract out of the Act. So contracting out is the exception rather than the norm. However, that said, just in the last few days, a very well-known KC in New Zealand has attracted media attention by saying that she is now seeing a very large uptick in people making contracting out agreements. And the reason that she gives for that is New Zealand's very high house prices. They are going down at the moment, but they are still very much out of kilter with what people earn. And her reasoning is that if people can actually get their foot on the property ladder, they are becoming rather more reluctant to share that property with a partner who might come along later. And so they are looking for ways to ensure that that property stays with them. And so they're making more contracting out agreements. And this KC estimated that about 25% of her clients were now making these sorts of contracting out agreements. And I should mention that the Property Relationships Act has specific rules for how you go about making a valid contracting out agreement. If it's made properly, it is very hard to set it aside. It's a very high bar that the court holds the applicant to in order to set it aside. I would also be a little bit careful about that KC's estimate that it's about 25% of people making contracting out agreements. She certainly attracts probably, I would say, people in the higher income bracket who are, I think, probably more aware of things they can do to get around the Act than perhaps the average punter in the street. So moving along there, how does the de facto fare under the PRA? Well, the same rules apply to marriages, civil unions, and de facto partners. Much like other places, so Kathryn was just talking about Ireland and the 2 and 5 year qualifying marks. We have a hurdle that de facto partners must get over in order to be caught by or covered or protected, whichever way you want to look at it, by the Property Relationships Act. Generally, people who make it to the 3 year mark will be treated just the same as spouses and civil partners. Those in relationships that do not make it to the 3 year mark will not be covered by the Act unless there's a child of the relationship or the applicant has made such a substantial contribution to the relationship that the court is satisfied that it would be seriously unjust not to make an order. So there are some ways there that the court can override that general 3 year rule. Nonetheless, if people in a de facto relationship find themselves in a non-qualifying relationship, they are out of the Garden of Eden of the Property Relationships Act, and they must fall back on other measures such as the constructive trust. So then, what is a de facto relationship under the PRA? The full text of Section 2D is on the final slide of this presentation, and in the unlikely event that you want to investigate it, I'm happy for these slides to be made available after this event. There is a list of 9 factors that is designed to help the courts decide if the couple were living together as a couple. And some of them are the length of the relationship, the nature and extent of common residence, whether there was a sexual relationship, the degree of financial interdependence or dependence, and that's just 4 of the 9. The important thing to note is that none of those 9 factors is essential. So these factors are really just indicators of a de facto relationship. They are not conclusive evidence in and of themselves. Case law, unlike Kathryn, who said, I think, mentioned that there were 8 cases, we have literally thousands of cases on this now. Case law shows that living together generally requires some sort of form of physical sharing, and coupledom is just demonstrated by some sort of mutual commitment to a shared life. So these are factual findings that the court will make. Now, I think it would be very remiss of me not to mention that there have been some problems with Section 2D. Now, I should say at the start that for many people, the de facto relationship settings in the Property Relationships Act are absolutely fine, and the rules work relatively well for them. But there are marginal outlier types of cases, and these are regularly tested in the courts. And the law has now been in for, next week it will have its 21st anniversary, and we literally have thousands of cases on these issues now. So some of the issues that are very hotly contested are commencement dates. As we know, unlike your formal relationships, de facto relationships are very informal, and the start date is often very unclear. Something that starts as a casual, uncommitted relationship can turn into something very different. So it's quite difficult to identify that start date. Sometimes even the very existence of the de facto relationship is called into question. And you might actually find people being caught unawares that they are in fact covered by the Property Relationship Act until they separate and one of them decides to have a go and bring a case and make an application. So the courts are really determining these things retrospectively and making assessments of fact after the fact, if you like. And I can think of cases where there have been relationships of many decades standing where the court has subsequently found that there was no de facto relationship. It was more of your mistress type of relationship. So certainly not every applicant is successful by any means. But I think the main takeaway is that it's a very uncertain pathway or gateway into the Act for some de facto relationships. But once you're into our very rigid sharing scheme. So remember, all of the relationship property is shared equally, and I'm not going to go into how we define relationship property with you. It's a science in itself. Also remember that another issue with de facto partners is that, well, the official message is that if people don't like the Act, they can contract out. But in some de facto cases, that is simply not possible, because if you don't know you are in a qualifying relationship until the court retrospectively tells you that that is the case, then any chance of being proactive about your making arrangements just goes out the window. So then, as I just mentioned a moment ago, the Property Relationships Act is celebrating its 21st anniversary next week. And so I'd like to sort of start concluding by saying, well, what's the public perception of the Act? Now, this Boren study, which, as I mentioned earlier, surveyed 1,300 odd people, recorded that almost 80% of interviewees were at least aware of the Property Relationships Act and that it had these sharing implications with it. Less promising were the figures that started to go down after that. Only 68% were aware that the Act applied to married and unmarried couples. And this is after these findings were made in about 2018. So this was after a good 16 years of the Act being in force. And that means that 32% of people obviously weren't aware that the Act applied to, I would say, unmarried couples. And even worse, slightly less than half of the people who answered these questions were aware about the 3-year threshold requirement for unmarried couples. Now, just anecdotally, I wouldn't be surprised by those figures. I teach a course on relationship property to senior law students, mainly 5th-year law students, and they never continue to, they always surprise me. Every year there are a number of them who are blissfully unaware of these requirements here about the 3-year threshold and so forth. So a lot more education is needed here, I think. In terms of general public acceptance of the Act, the Boren findings found that 74% agreed with the Act, but I think we need to be a little bit careful about that finding. There was a later phase of the study where detailed interviews were done with people who had actually been through the PRA process. and they displayed quite a bit of dissatisfaction with how the Act is working. Some people were just resigned to the law being as it is, and they just wanted to get the process over and done with and move on with their lives. Some people reported that, particularly in the de facto context, where it's so fact specific, and some of the previous speakers have mentioned that as well, that they really disliked all the intimate details of their lives being rolled out before the courts in a particularly voyeuristic way. So I think probably that agreement is rolled up with just, well, it is how it is. And some people may have been perhaps a little bit resigned about it. And so I'm going to conclude now. There are more slides here. I'm not going to burden you with them. The following slides, which I'm not going to touch on, look at some anomalies where de facto relationships are not treated the same as formal relationships, marriage and civil unions. There are still some anomalies in New Zealand, not that many, but a few. But I just want to conclude with some of the, whoops, I've gone a bit far there, some of the reform proposals that have recently been swirling about in New Zealand. Our Law Commission completed its review of the PRA in 2019. Now, interestingly, it did an in-depth study on the de facto provisions, and it was generally satisfied with the current definition of de facto relationship and the qualifying period. But the Commission did acknowledge that there are problems around the definition in terms of giving greater clarity about what is likely to be a qualifying relationship. And so it recommended a statutory presumption that where people have maintained a common household for 3 or more years, then that's a weightier factor to take into account. The Commission did not make any recommendations for other sorts of relationships like polyamorous or domestic relationships. They said further research needed to be done on that. So I think the general message from the Commission is that we can tinker with the de facto provisions, but in general, they're satisfied with what we've got. So I think really in terms of recognition of de facto relationships in New Zealand, it's yesterday's news. We have embraced it. There's no question that they're in the fold for just about every purpose. The Law Commission did make a lot of other submissions about other parts of the legislation, and it was critical about the type of property that is up for division and the shares. So I think the battlefield has shifted from where it was 20 years ago. Should we let de factos into the fold? It's moved away from that. And I think that the next battles will be fought about what property should be caught by the Act and how it should be divided. So just to conclude, in terms of giving de factos, cohabitants, legal recognition, I think things are working tolerably well for the majority, with the exception of those niggly cases that kind of operate at the periphery. So contrary to the henny penny catastrophizers back in 2001, who predicted that the sky would fall in if we gave de facto partners equivalent rights to spouses under the Act, I think those fears really have come to very little. I think there are a lot more things to be worried about in the current world, and my thought would be that as a society, we are better off morally for recognising de facto partners as having pretty much equal rights with spouses and civil partners. So I will leave you in peace now, and thank you.